22, in this case, Your Lordship, TCR was called for. It is not take to the record. I have verified that already the registry has received the TCR. So may be directed to bring that TCR.
22 TCR to call করে দিব
No, already is there. A registry has received. Oh, please.
May I please, Your Lordship? Item 32, Lordship. Today I have some personal difficulties. Can it come next week, Lordship? 32. I have taken the concern of other side, Lordship.
list again on
Next week, Lordship. Any? Blush.
Maybe it's a loss. Item number 12, my lord. Well, pass over the number. For this day, my lord. For next week.
yes
No problem. Okay, please, your lordship. Lordship, item number 14. LCR was called for, but not received. Interim is there, my lord.
of TCR has not been received. List again on so and so interim order passed earlier to continue next date of listing.
Okay.
May I please, Your Lordship? I beg to mention item number 54, my lord. TCO was called for, my lord, has been received, my lord. We need some time to go through, my lord. It will be after a week, my lord.
50
Accident matter, my lord.
54
Yes, my lord.
TCR received.
Yes, my lord.
TCR received of the prayer of learned counsel for petitioner. List again on
February. Obliged. Another item, my lord, item number 48, my lord. Our name has been wrongly shown, my lord. We are not in this matter, my lord. We have never signed Wakalatnama also, my lord.
all the names.
Except P. Borthakur. It's the PP, my
State
lord.
has filed this, my lord, revision.
State has filed. Let it come, we'll pass order.
Obliged. I mean, I did.
Your Lordship, I beg to mention item number 9. Your Lordship, I request that the item be adjourned for the day. Your Lord.
Item 9. Yes, list again on.
Please, your lordship, I like to mention item number 41, my lord. To the agenda. My lord.
Yes, indeed.
Next.
Please, Your Lordship. Lordship, I beg to mention item number 7, Lordship. Lordship, I request to withdraw this matter, Lordship.
So on the prayer of Mr. Deep. That is dismissed as withdrawn.
Deeply obliged, Lordship. May I please, Your Lordship? Lordship, I beg to mention a listing of a matter, new matter, motion.
Go to senior bench.
My lord.
Item number 1 and 2 wrongly listed for motion. Earlier, case diary was called for, my lord.
CD has been received.
My lord, regarding because matter listed for motion, my lord, so CD.
Kindly,
Short date, my lord.
tomorrow, your lordship,
Day after-
a hearing, your lordship, under the head
Day
of
after
lordship.
tomorrow.
Is the matter again on, the case has been wrongly listed in the motion column. Is the same, the bail hearing column on
6/2, my lord, day after tomorrow.
item 1 and 2.
Please, your lordship.
So,
Yes, lordship, at the 6 days.
right, CD, notice to respondent number 2.
Short date may be given, lordship.
Because 90 days.
Yes, give a date.
Be over, lordship. 9
9.
February.
May I please, your lordship? Lordship, NDPS in between, lordship, petitioner in custody for more than 90 days, lordship. And but Lordship contraband recovered from one. Lordship, kindly have a look at the Azahar page 16.
What is it? Commercial quantity?
Commercial quantity
In between, in between.
charge sheeted case, no?
Are seated, but in between, Lordship.
Anyway, NDPS matter.
So Lordship, kindly have a look at page 16. It was recovered from one Lal Rington Hamar, not from me. It is clearly stated in last down below, Lordship.
We don't know what is the material against you.
But
All right,
But-
CD, give a date.
25 to 1.
Wait, this is the Lordship. Lordship, item 5 and 6 are arising out of same FIR, my lord. 5 and 6, and they are in custody, my lord, since 23/07/2025.
You got NDPS.
Yes, my lord.
Charge sheet
Charge
is
sheet
case.
is there, my lord. We have annexed. So if Lordship can requisition and thereafter, my lord, decide the matter, my lord.
Same date.
My lord, can even third week of this, 18th, my lord, 18th February.
18th, my lord, already.
Kindly, my lord.
19th, my lord.
Kindly,
19.
19. 5 and 6 same, my lord.
TCR, huh?
Yes, my lord, TC.
And copy of TCR along with. Showcase to, huh?
Thirty-nine is listed for bail hearing, my lord, and 49 is for motion. This case, charge sheet submitted. no? Or something. no?
For some time. Well, after some time. What has happened? Nobody's aware of what? Timing, huh?
Wait, listen. Fox is here, my lord, notice may go to the. Here may can be covered.
Charge sheet has been submitted. All for the TCR, scan copy of TCR.
2nd of March.
To the respondent number 1, ma'am.
Are the display boards working or not outside? Working.
Fox is here, my lord, notice maker.
Notice to respondent number 2.
Nice.
In this case, my lord, it is the last case kindly peruse your lordship. Tuition master, my lord, himself, my lord, the mother of the victim, but herself, my defaulter, to pay the rest of the amount of the tuition fees. And subsequently, though he did not went into the house of the victim girl, lost this other. Kindly peruse the last page, my lord. Last page. সন্মানপূর্বক বিনীত নিবেদন এই যে পদকীয়জন মোৰ টিউচন শিক্ষক হয় বৰ্তমান মই 10ম শ্ৰেণীৰ ছাত্ৰী যোৱা ইমান তাৰিখে ৰাতিপুৱা প্ৰায় 11টামান বজাত পদকীয়া মোক গাঁৱৰে পথত লগ পাই মোক
Call for the CD lordship. Lordship, Lordship, item number 50 and 51, Lordship, the call for the CD lordship, the short date lordship.
50, 51.
Lordship,
Oh,
supplementary lordship.
CD.
On 10 lordship.
10, it will be available.
11, Lordship.
1011, my lord,
Which station?
Kazolgaon, my lord, from Sirang district.
The arrest memo, in the arrest memo, Lordship.
Come so, whether it will come so soon, that is the question.
10 or 11, Lordship.
17, my lord.
Wrong date, Lordship. That should be.
1313.
13.
Yes, Lord.
It please your lordship, kindly adjourn the matter for the day, lordship.
For the day,
Yes, lordship.
the prayer of learned counsel, the petitioner lists the matter again on.
It please your lordship, kindly withdraw the petition, lordship. Petitioner has been arrested, lordship.
Hmm?
Withdraw the petition.
Withdraw. It is submitted that the petitioner has already been arrested and hence the matter has become infructuous, dismissed as such.
So bless lordship.
May I please, your lordship? I have been behind the bars for the last 43 days. What had happened in this case is, lordship, on secret information, the police went to a person's place, search was conducted, money was recovered, FIR, lordship, at page number 18. Money was recovered, stolen cars were recovered, stolen bikes were recovered. Subsequently, the person escaped. Then, a few days later, I was called to the police station and I was arrested. As per the forwarding also, only because I had telephonic conversation with the main prime accused who is absconding, so I was arrested. If your lordship comes to the forwarding. Forwarding at page number 30, lordship. The grounds of arrest. Page number 30. The investigation indicates that the accused, Sirajul Islam, that is me, has been running a scrap business used as a front to dispose the bikes received from the prime accused, Dibyajyoti Datta, who is still absconding, in order to evade arrest. Under section so and so, anyone who is habitually receives or deals in property, they have the reason to believe this 317 subclause 4, that is habitually receiving stolen property. I do not have any pending cases relating to theft of property or any goods, lordship. This is the first time. Then point number 2, during investigation, it is found that the accused was in continuous touch with the prime accused Dibyajyoti Datta over mobile phone. This is the only reason why I have been arrested. As nothing was recovered from me, as per the FIR, search was conducted in the home residence of Dibyajyoti. Later on, what happened, your lordship, the police gave a petition for adding NDPS 27A, that is financing, though no NDPS material was ever recovered. Not from my possession, even from the possession of the prime accused, only certain tobacco boxes were recovered. That's why no NDPS sections has been attributed. So, come between the purview of habitually receiving stolen property, there has to be at least a conviction relating to stolen property or at least a case pending. Here, the only ground the police states that because I was earlier, there are 3 pending cases of NDPS, that is for small quantity for consumption. For the last 43 days, lordship. This section is totally not attracted towards me. And 27A, some money was recovered admittedly from the possession of the prime accused who is absconding. That comes, lordship, is page number 39. Page number 40, effective part. This is the petition given by the IO. Second paragraph. That's During the search conducted at the accused Dibyajyoti Datta's residence in so-and-so, recovered Indian currency, 8 motorcycles, 7 plastic tobacco containers suspected to be used for distribution of banned NDPS items.
Total 8 numbers of bikes recovered from the my lord residence of Dibyajyoti Datta, and my lord from the grounds of my lord from the grounds my lord it reflected that Sirajul Islam is in continuous, he is the my lord owner of the scrap owner, my lord. He is in continuous contact with Dibyajyoti Datta. So all those bikes which were my lord suspected to be theft, my lord, ultimately all those bikes were my lord disposed of in the my lord scrap of the present petitioner, my lord. So it seems that this is a my lord huge my lord maybe a nexus of my lord involved in my lord theft of bike, my lord.
In paragraph 12,
Only
Lordship, I have stated I am not the owner of the scrap. I am a mere driver due to my professional connections.
Has been running, my lord, grounds of arrest, my lord, ground number 1. The investigation indicates the accused Sirajul Islam have been running a scrap business used as a front to dispose of bikes received from the prime accused Dibyajyoti Datta, my lord, who is still
Lordship,
absconding.
that is the allegation, but they could not produce anything that the scrap belongs to.
Habitually receipts
I
or deals
categorically
in
deny that
property
the scrap is mine.
have
Lordship.
reason to believe is stolen can face.
And further, nothing was recovered from the scrap. If they are harping on the scrap thing, it was recovered from the residence of Dibyajyoti, not from me, Lordship. Then subsequently, I was called as per this section notice under section 47. It shows I was arrested from the police station. So I was not found in the place of occurrence also.
Without the help of the present petitioner, Dibyajyoti would
Already
have never
43 days, Lordship, I
have
was
been
not
able to
recovered.
dispose
Nothing was
of-
recovered from me. I was not present at that point of time. As the FIR clearly states, it was Dibyajyoti, and later on he escaped due to darkness. The police could not catch him. And later on, they called me to the police station. I go to the police station, and then I was arrested. To attract such sections of habitually receiving stolen property, at least there has to be any one pending case against me.
Anyway, 27A is there rightly, wrongly, we have, without seeing the CD, how can we say?
Scan copy of TCR, my lord, search sheet submitted already.
Oh, search sheet also submitted.
Scan copy may kindly be called. Lordship.
And the other one?
No, same PS, my lord.
I have
Same
for the
He is
email.
Dibyajyoti Datta and one is Sirajul Islam.
Learned Council and Learned Edition. Search sheet in the case has already been submitted by CS number.
Search sheet number 42/26 dated 1/2/26.
The scanned copy of the TCR along with CD. Please take a note.
On my lord 25/2.
Can it be on 16th, Lordship? Yeah, already inside for the last 44 days. Nothing was recovered. Can it be on
Already 16.
16 February? Deeply obliged.
39 and Kimanusalit.
49 and 39, Lordship. Deeply obliged. May it please your loss.
Worship. Passover for time being.
To adjournment, listen. CD was received, I think, in this case.
Item number? So 15, yes, my lord, CD received.
None appears for the petitioner. In on. So and so, CD received. It is scan copy or
CD, man, CD received.
retained?
Wait, please, your lordship. Lordship, this is a regular bail application, lordship,
In this case,
177.
POSCO, my lord, here, my lord, notice duly served on 6/1/26. On earlier occasion, my lord, there is a direction amicus will be appointed in case of non-appearance on behalf of the respondent on next date.
Which
One-
item? 16.
16 years. Is served on 6/1/26.
Is this POXO?
POSCO.
POXO 6 and 6 is there. 60.
Not in this case, POXO is there, but the victim already examined. And after gone through the deposition of the victim, my lord, Honorable Court was granted interim bail to the petitioner without her appearance. As from the deposition of the victim, POXO is not enacted, my lord.
So we'll go by what is in the TCR then. Unless you want to wait till then.
Yes.
Because amicus curiae was not appointed, that's
Focus not.
So it was appointment of amicus
Your
curiae.
lordship may today, your lordship may fix one amicus, in the meantime. This POSCO, my lord, here. 18 now. Already service completed, man. Amicus may be.
Sorry for little. Lordship,
Service completed.
Yes, service completed.
Service on respondent number 2 is complete, but none appears. So and so is appointed as amicus. CD
My lord, TCR, my lord,
received. TCR has, scan copy of TCR has also been received.
received.
Copies be served upon the amicus. Please the matter.
23 to
23.
In this case, my lord, an innocent have been in custody, my lord. I was arrested on misconception of facts, my lord. Kindly see,
19, my lord, start sheet submitted, my lord.
my lord, kindly see para,
Commercial quantity of NDPS, my lord.
my lord, kindly see page.
What is your name?
My name is Dilwar Hussain. My lord, kindly see page 4, para 5, my lord. Para 5 and 6. How I have been arrested, my lord, and why, my lord.
And today, my lord, CD and my lord, this year, nothing is with me, my lord, because case is, my lord,
My lord,
earlier
kindly see for a moment
CD was called for, my lord.
my case, my lord. How I have been arrested, my lord, and why.
That is your story.
My lord, this is that is substantiated with the annexures, my lord. Kindly see these annexure I have annexed, my lord.
What?
I have annexed, my lord, annexure 4 and 5.
He can.
This is the sale date of the
How can I
vehicle.
believe, my lord, those? annexes?
4 and 5, annexure page. Give us.
Page, my lord, 21 and 24 and 25. This is the sale date, my lord, of
Who
that.
knows about its authenticity? Yes.
My lord, along with charge sheet, my lord, may be called for, my lord. Short date may be given.
Charge sheet has already been submitted. Right. CS number.
Case number, my lord, 7/26. Dated 30/1/26.
Scan copy of the TCR along with CD.
A short date may be given, my lord. I'm claiming that I'm innocent. I will prove it, my lord, on the next statement.
26 to, my lord.
Lordship may pass over that matter for the time being.
Twenty-one, my lord, as per my instruction, today I have received notice already served. POSCO, my lord.
POXO 6 is there, my lord, and out of the, my lord, 7 witnesses already, my lord, 5 witnesses are examined and discharged. My lord, IO is partly cross-examined, my lord. TCR is called for, my lord, TCR is received, my lord.
TCR received. my lord.
PW1 is, my lord, victim, my lord.
All right, we appointed amicus then.
Yes.
Learned additional PP on instructions received submits that service on respondent number 2 is complete, however, none appears. So and so is appointed as amicus. Copy of petition be served upon the amicus. The matter again on
17-2.
My lord, a short date because, my lord, the IO is, it is fixed for cross-examination of the IO, my lord, further cross-examination.
let it happen. What is the matter? Is it up to date TCR? What is?
Yes, my lord, up to date is there. Only one last order is not there. But the victim's statement and all the statements are there, my lord. PW1 is the victim, my lord.
All right. 17.
Oblige.
Twenty-two, my lord, scan copy of TCR not received.
CD was called for last date.
Scan copy of
Scan
TCR.
copy, at that scan copy received, registry received,
So charge sheeted.
charge sheet material. Registry has received, I have,
Huh?
morning I have mentioned that registry has received, asked.
File nahi ki.
After some time. After some time,
We'll have to go through.
Order
the
or nahi. There is no order calling the TCR. It is CD only. So how did registry receive the?
well, another connected case is there. Yes.
Huh?
Another co-accused also filed case. I have, yesterday I have verified your lordship.
But that number you should have given. All right, let it come tomorrow. In the meantime, you furnish that number. He will.
Number to case number.
112. Tomorrow, your lordship.
Please, your lordship. Please, your lordship. On again, court number 8, so kindly pass over the matter for the time. For M. Kumari, Retainer Counsel, CA.
Time being.
Timing.
We'll wait, man.
Mail, please, lordship.
24, my lord, case diary not received. my-
We have taken step also, my lord. With regard to the respondent number 2, it was POXO is, yeah.
They did not received. Respondent number 2 is also yet to be served. Just again on.
I'll give a short date, my lord. It is from Rongia, my lord.
16-2.
But not 617, my lord.
17.
Obliged.
May I please, your lordship? This is a regular bail application, my lord. The allegation is POCSO, and the petitioner is behind the bar. It has 92 days, my lord.
Scan copy of TCR received and my lord, as per my instruction, my lord, service also completed, my lord.
Last date a CD was called for, my lord.
Scan copy of TCR, my lord, already
Charge sheet case, is it?
TCR received, my lord, was list.
Same copy of CD was called for, my lord.
Trial has not commenced, it seems. Filed very recently on 23rd. This PCRS call for has been received. Notice on respondent number 2 is also complete as submitted by learned additional PP. But none appears for the respondent number 2. So is appointed as amicus. List the matter again on
What date may be given, my lord?
copy of petition be served upon the amicus.
13-2.
Highly obliged, my lord.
TT application, lordship. In this case, petitioner was arrested on 6/6/2025, lordship. CD was called for.
CD not received, my lord. IO has prayed for some time, my lord.
But similar matter fixed on 9th, lordship.
Already CD not received, list the matter again on 9.
Obliged, lordship.
Number 2 education.
Yes, more with you.
May please, your lord.
27 search sheet submitted, my lord.
Charge sheet has been submitted by CS number.
Right, my lord. CS number 9/26 dated 27/1/26.
The scan copy of the TCR along with CD.
Third of March. Any March, 3rd March.
Please.
28-29, my lord, search sheet submitted, my lord.
Yeah, lordship, allegation is pilferage of oil. And the petitioners, in both the petitioners were arrested only on the ground that the pipelines from where the pipes were found, land over which the pipe were found, belongs to the petitioner of the item number 28. And he is the known to the petitioner of the 28, therefore the 29 petitioner of the 29 has been arrested, lordship. But there is an agreement, lordship, in between the original landowner and the petitioner of the item number 28. And the petitioner in item number 29 is nowhere involved. Let's come to the forwarding report at page 15, lordship, ground of arrest. Page 15, lordship. 2. Oil pilferage was detected from the area taken on lease by one of the accused person as per an agreement with the landowner, clearly establishing exclusive access control and involvement of the accused in the commission of the offense. So the only ground of arrest is that the land over which the pipelines were found belongs to the one, this is petitioner Sharat Karmakar, that is the petitioner of the item number 28. He has made an agreement to purchase the said land with the original landowner Pranoti Fukan Soikia. And when the sale deed was not executed, he has issued a legal notice that is at page 17, Lordship. And already 48 days is over, Lordship. Page 17, Lordship. I am no way involved.
Land belongs to this Prahlad Gogoi.
No, land belongs to one Pranoti Fukan Soikia. That is come to page number 17 of my petition, item number 29, Lordship. 29. Page 29, page 17, Lordship. Land belongs to this Pranoti Fukan Soikia. She entered into an agreement with the Sarat Karmakar. And when this landowner failed to execute the sale deed, so he has issued this legal notice. And he has made the payment to the landowner. I am no way involved with this land. But police has arrested Mayor on suspicion that the petitioner is known to Seth Sarat Karmakar. Nothing material has been recovered from the possession of the petitioner, either of the petitioners. And already 48 days behind the bar.
Land, otherwise, my lord, admittedly, land is exclusively under control of the present. Although landowner may be, my lord, someone other, but my lord, he is the person, my lord, from the ground. Awareness reflects that, my lord, who is under the exclusive control of that land, and at that point of time, my lord, he is doing all these offences by establishing, my lord, that.
Who is this? Pune Police. Land is not in my possession. Land is in the possession of the Sarat Karmakar. Agreement was entered with the Sarat Karmakar. And when the sale deed was not executed, he has issued the legal notice for refund
You
of
are
the
appearing only for in 29.
29 Lord.
I am for 28, Lordship.
The only ground of arrest, because the land involved in the offences belongs to one of the accused person. Apart from that, there is no allegation, nothing incriminating material has been found from the possession of the petitioner. And the land is a Patta land, belongs to Pranoti Fukan Soikia. Considering the length of detention, let's say already 48 days is over, Lordship.
Even blank. That charge sheet has been filed against you also.
Yes, Lordship. Then also considering the length of detention, Lordship, already 48 days in behind our Lordship. The ground of that is land.
Lordship, time with regard to item number 28, Lordship.
We are on 29 at the moment.
Lordship.
Additional application under 7. Three, the bail petition. Learned counsel for the petitioner has submitted the present petitioner, Prahlad Gogoi, is connected to the alleged offense. By reference to the forwarding report that no specific allegation, evidence, material has been referred to the grounds of arrest as against the present petitioner. Reference is also made to the annexure C notice is of co-accused Sarat Karmakar, one Pranod Soikia, wherefrom it appears that land that is place of occurrence under an agreement of sale in between the aforesaid two persons. And therefore, the present petitioner comes into the picture as the land where the alleged offense took place was neither under his control or possession. While the petitioner has already spent 48 days behind bars. An additional PP has objected to the prayer for bail as the charge sheet has already been submitted. Are you sure that he has been named in the charge sheet? No.
Yes, well, against both the accused persons.
Against the present petitioner as well. Para having regard to the submissions of learned counsel for the petitioner regarding the lack of involvement of the present petitioner. Also upon perusal of the documents of declined to release the petitioner on bail. It is directed that the so and so shall be released bail of rupees 1 lakh with 2 securities of like amount. Learned Dhaka Magistrate. Provided that the petitioners regularly participate in the trial if one commences against him and shall not try to influence the witnesses in any.
Public.
Since disposed of.
Please, your lordship.
Yes.
Regard to item number 28, lordship. Kindly peruse annexure E, lordship, page 44, lordship. The agreement between the petitioner and that Pranati Phukon Soikia, lordship, which is duly notarized, lordship. Page 44, lordship. This was executed on 12/12/2024 at Nazira, lordship, page 46, lordship. And it's a Patta land, lordship. Thereafter, since lordship,
Yes.
since the sale deed was not executed, lordship, in fact, the petitioner sent a legal notice to the said Pranati Phukon Soikia, lordship. And thereafter, on 18, lordship, the petitioner was arrested, lordship. Also, this is an agricultural land, lordship. Here, patta number, DAG number are clearly mentioned, lordship. Since sale deed was not executed, even after taking the advance amount, lordship, he had sent this legal notice, lordship. Thereafter, he was arrested, lordship. And in the ground of arrest also, it has been mentioned, lordship, that this agreement was executed, lordship. Already 48 days, lordship.
Where from did you say that it is under his control?
That is in the grounds of arrest, my lord. That is already pointed out by my learned friend, I appearing in item number 29, my lord. It is in grounds of arrest, ground number 2. So it seems that, my lord, yes, they are not the, my lord, landowner. The oil spillage was detected from the area taken on lease by one of the accused as per the, but specifically not mentioned, my lord, who is the accused, but the agreement is between both the accused, my lord. It is there in the notarized agreement reflected.
Agreement is between one accused and the Pranati, this person.
No, my lord, between two accused, my lord. Two accused persons, your lordship.
Age?
In the agreement itself, my lord, Pranati Prahlad Gogoi and my lord, second Sarat Kormukar, my lord. Between both the two accused persons.
I'm clarifying, lordship. In the agreement, though there is name of the Prahlad Gogoi, nowhere his signature is appearing, and that substantiates the legal notice, because legal notice has been issued by the Kormukar, not by the Prahlad Gogoi. There is no signature, lordship.
Your lordship may kindly peruse page 44 of the present petition, my lord, item number 28, my lord. That is the notarized, my lord, stamp paper, my lord. Also reflects second party, Prahlad Gogoi and Sarat Kormukar, my lord. And in the agreement also name of the both the accused persons is there, my lord, in the column of second party.
The land is admittedly of one Pranati Phukon Soikia, lordship, which has been clearly reflected in the ground of arrest also, lordship. And the legal notice annexed by the respondent in the item number 29, lordship.
No, you issued the legal notice.
Lordship, yes. Because since the agreement was executed, lordship, which was duly notarized on 12/12/2024, lordship. But since sale deed was not executed, lordship, therefore he had sent a legal notice, lordship, before arrest, lordship. So Lordship, 48 days already behind the bar, Lordship, investigation already completed, Lordship. Since agreement was executed, thereafter, only on the ground, he was arrested, Lordship. With any condition, Lordship.
Value of land is, my lord, more than 8 lakhs, and my lord, this agreement is, my lord, notarized agreement, sale agreement, my lord.
Notarized agreement, Lordship.
Agreement, this is agreement for sale, it will not be registered.
Lordship, it is the agreement, Lordship, only. And witnesses are also there, Lordship.
Otherwise, material only on the ground of length of detention and, my lord, completion of the search. Otherwise, my lord, it cannot be at this point of said that those documents are whether those are.
Third, learned counsel for the petition and learned additional. Same as last order, okay, up to that paragraph. Our sheet has already been submitted. And the petitioner has spent 48 days behind bars. Considering the length of detention and the fact that the completion investigation has been completed, and also having regard to the material available, forwarding report further detention of the petitioner cannot be necessary. Same order, okay, release.
Oblige, your Lordship.
With the permission of the court, madam, I'm sorry to interfere with the court proceedings, madam. With regard to item number 27, charge sheet have been submitted. My lord has called for the records on 3rd of March, madam. He's behind the bars for last 57 days, madam. Can it be a bit earlier, madam? Item number 27, madam.
What is the statutory period?
Well, there 27A is also there, madam, but the perusal of this charge sheet, from the perusal of the forwarding report, it will be evident that 27A is not attracted, madam. Arrested only on 8/12. 8/12, today is 57 day, madam. Not commercial quantity, madam. While 27A is there, my lord, it may extend up to 1. Yes, yes, but the.
Already give a date in February.
Yes,
Then.
on, my lord, when 21/2. From Bozali. Can be on 17/16, madam. 18. From Bozali, madam. 18 to 18. I'm deeply obliged, madam. Much obliged.
Please, Your Lordship. This case, my lord, is a case under POSCO, my lord. 6 of the POSCO Act, my lord. FIR, your lordship will find at page. Page 8, my lord, lecture 1, my lord. Was lost by one. Murder of the girl, my lord. Thoroughly, that's the murder of the victim, my lord. Is her daughter owner, is it about 16 years or Bhagwan?
This is the.
Next, please, my lord.
Item 30, demanding. Seems that my lord petitioner is entitled for default bill, my lord. Already today is 63 days, my lord. Charge sheet not yet submitted.
Charge sheet has been filed. I inquired in the office of the special judge.
Learned counsel for the
Charge sheet
petitioner.
submitted.
The case is registered under
My lord,
section.
as per his instruction, my lord, charge sheet submitted, so I will have to get the instruction after some time, my lord.
Submitted.
Submitted. I inquired in the office of the special judge.
Number 2 was an number 2. After some time, I will get the.
Obliged, my lord.
Last date also nobody appeared. It is available. No.
No, my lord. They are interim granted, my lord, to the petition. CD received. Yesterday, I contacted the IO, my lord, regarding the present case. He is the principal of the, my lord, Miles Bonsall Residential School. Regarding, my lord, during ragging, the son of the informant was assaulted by his seniors, my lord, and thereafter this FIR is lodged, my lord, against the allegation against the petitioner is that being the principal, he is also responsible. While granting interim, my lord, there is no such direction for appearance before the IO, my lord. As and when called for the IO, my lord, that is the also, as per my instruction, he has also not appeared. Such instruction for it.
None appears for the petitioner. CDS called for has been received.
Yes.
It appears that while granting interim protection to the petitioner, wide order dated 22/9/25, petitioner was directed to cooperate with the investigation and to appear before the IO as and when called for. Is there any notice?
No, my lord. IO has also, my lord, not asked him to.
But the CD reveals that the IO has yet to call him. Interrogation. In regard to the of the present petition is disposed of with the direction to the petitioner to appear before the IO within a period of 7 days from today. Will not dispose of, he'll appear and then we'll fix a date. Dispose of. Directed to appear before in a period of 7 days. Recording his statement. Date after 10 days.
5th of March.
Who will communicate this order? Nobody appears.
Yes, well, that is the review.
Let's see.
I will have to inform the, my lord, concerned council whose name.
Petitioner for Rossi is on interim by dated 17/10/25, and after he had appeared for the IO lordship. And to my respectful information received from the petitioner lordship, charge sheet has been submitted, and in the charge sheet, his name is not included lordship. He is the owner. And I have checked in the e-courts services, the case is numbered as 71/25 special NDPS. There his name does not reflect.
Charge submit will target in
মানে e-court of my poa moto tar-
But you get the instruction.
Then I will have to get the instruction. Well,
They
day
are
after tomorrow-
submitted on behalf of the petitioner that the charge sheet has been submitted wherein he has not been shown as an accused. Learn an additional PP to obtain instructions, list the matter again on
on 6/2.
interim order passed earlier to continue till the next date of.
Yeah, please, Your Lordship. This is 482 application, my lord. I am on interim since 10/11/2025, my lord. I have appeared, my lord.
This case also was a charge sheet submitted, my lord.
There was an order for his appearance before the IO.
Yes, I have appeared, my lord.
After that, charge sheet has been submitted.
Yes.
Dated 10/11/25. Okay. 1, 2, 3. Five, 6, 7. Order dated 11/25, the petitioner was granted interim bail and was directed to appear before the IO within a period of 7 days. The date of the order. It is submitted on behalf of the petitioner that accordingly the petitioner has appeared before the IO. Statement was recorded. An additional PP submits that in the meantime. The charge sheet has also been submitted. Having regard to the of the allegations and the fact that the allegation of the case is over, wherein the petitioner has cooperated, it may not be necessary to take the petitioner into custody for the purpose of the trial if one commits. Order of interim pre-arrest bail dated 10/11/25 is hereby made absolute. Following condition. Petitioner shall writ at the trial same as the earlier order, okay? Shall not directly, indirectly. Last para. and stands disposed of accordingly.
Ably obliged, my lord.
Thirty-five, my lord, in this case, final report submitted. No?
It's infructuous.
My lord, she has submitted that after submission of final report, my lord, the again case has been initiated against her.
Yes, Lordship. Lordship, in earlier order, Lordship has already granted interim bail to the petitioners after they had received summons, and they have accordingly appeared before the learned trial.
What happened after that? They submitted FR.
Yes, after the IO had submitted FR, the complainant again gave a protest petition for which the case was again registered as a complaint case, and later on the summons was issued to the petitioners.
It is a different case, but in this present case, my lord, regarding investigation early,
It was submitted earlier.
regarding again initiation of that case by the complainant, my lord, that oh, he took on because of that, my lord, she has again approached by
That is already transpired
yes.
in passing of the interim.
He did not. This year has to be controlled. This year received, then, my lord, I will have to go through the this year, my lord, after some time, my lord.
Already appeared, Lordship, on 6/12/2025. They've appeared, and the next date is fixed on 12th of this month for copy, Lordship.
Here will now show what they have filed
Let
just a
them appear.
complaint and
Yes, yes. Let him appear.
dated 28/11/25. By order dated 8/11/25. Hearing. Bail. Can you add paragraph? Order. Trademark. Okay. Having regard to the custody, it will not be required for the petitioner to be taken into custody for the purpose of the proceedings before the learned magistrate. Accordingly, the order of interim pre-arrest bail dated so 28/11/25 is hereby order provided that the with the further proceedings. It is then disposed of accordingly.
To applies, Lordship.
Your Lordships. Anticipatory bail application, case diary was called for and service report was also called for, my lord. It would be the third occasion. Perhaps, my lord, neither is available. And the issue here is, my lord, this petitioner is a student of HS second year and his exams are scheduled to start from 12th of February, my lord. Case pertains to, my lord, FIR Lordship will find at page 11. 19-year-old boy and 17-year-old girl, my lord, were in a relation. Ended up having some sort of a sexual relation with her. Their father has lost his FIR. 11. Did he not receive money and not? Equal opportunity has been given. This adequate opportunity has been given and they have not been able to do the matter. May I pray that some sort of a interim protection may be extended, my lord. Otherwise, lose his final year, my lord, and end up losing one academic. His 17 is the certificate issued by the principal of the college where he is studying, my lord. Admit cards and all he could not procure, that those have been issued, but he is unable to go to the college to collect them.
Any short date may be fixed, my lord, on. Where from?
From my lord, Huzai, my lord. Hazar PS. Even if a lordship fixes it on 10th, my lord, the issue of service, if on that day service is complete and they don't appear again, amicus will have to be appointed.
No, we can consider the interim on that date. If right now we have nothing, no statement of victim or anything.
FIR, if your lordship goes by the FIR, it appears, seems to be that of a adolescent love story, my lord, that has gone wrong. But at the end, my lord, realities of today, my lord, though the statute has drawn a line at 18, but these are happening, my lord. Lordship may take his age as a mitigating factor, 19 years old. Keep it open for final disposal subject to the case diary and the appearance of the other side. But even if some protection is given on 10th, on 12th, if his exam is there, my lord, but too less of a time for him to appear, my lord.
Heard learned counsel for the petitioner. Learned additional PP. Number 2 is not complete. The third occasion on which the IO has failed to produce the case diary submitted that the petitioner, who is a higher secondary
Second year. I think second year, my lord.
second year, due to appear for his higher secondary final exams commencing from
12th of February.
12th of February. Having referred to the above, provided that the petitioner shall be released on interim bail of rupees, then at one surety of like amount to the for sick leave. But provided that the shall cooperate with the investigation, try to influence the witnesses in any manner. The matter again on
5th of March. Completely available. 4th. Completely available.
Right, Lordship. Lordship, the petitioner is a grass cutter of Forest Department, Lordship. The Lordship will find the FIR at page 18, Lordship. The allegation is that
Did you receive money?
yes, what exactly is the allegation?
Lordship, that the informant and his associates are beaten up by the accused, and the accused fired 2 rounds of shots from the gun of the forest guard. He is the grass cutter, Lordship. What exactly story is that the informant along with his associates are making party just behind the forest camp, Lordship. And they are just for making fun, they are shouting, defense are coming. And they pelted a stone to the camp. Then the forest guard, Lordship accused, the grass cutter, came out and requested the informant not to stop this situation, otherwise it will make volatile in the forest situation. This is the story, Lordship. He has already been placed under suspension. His statement has already been recorded, Lordship. Allegedly, the incident took place on 14th of October, and the FIR was lodged on 22nd of October.
Yes, PP.
Yes, my lord. Otherwise, statement of the injured person is there and medical report also available, my lord. Bullet injury is also there, my lord. Otherwise, nature of injury is simple, you know.
Order dated 1912. Has been received and it appears. The statement is there.
Statement is there.
But the petitioner has already been recorded by the IO. The perusal of the CD, there appears to be appeal against the present petitioner. Or perusal of the medical report only indicates simple injuries. The leg of the, to the toes, TOES. Good person. Having regard to of the investigation. Therefore, pre-arrest bail is allowed. Order of interim pre-arrest bail dated 1912. 5 is hereby. Same conditions. Hence disposed of holding like the CD.
My lord, case diary received and my lord, notice also served, my lord.
May it please your lordship.
POSCO is there, my lord.
Also,
The page,
Service report received, my lord, notice.
the page number 8, lordship.
nobody appears.
No, my lord, today I have received regarding service report.
What is your instruction? What have you received?
Only notice served to the, my lord.
Any date is mentioned?
On 3/2/26, my lord.
Today's date is mentioned.
3/2/20, yesterday, my lord. 3/2/26.
This was yesterday. No, no.
3/2/26, my lord. Notice served on 3/2 yesterday, sir.
So too little time. Has the next date been given in the notice?
Is my lord, actually, my lord, that annexure A is prepared by the, my lord, registry on that basis annexure A that was served and thereafter after taking signature, my lord.
Registry notice contains the date when it is next fixed, is it not?
Only
Because we are facing this issue every now and then. Notice is served, but there is no date of the case, next date of the case mentioned there. Or the court.
That format has to be changed, my lord. That format annexure A, my lord.
High Court's format.
So, my lord, actually, there are probably after serving the notice, my lord, the copies which were already supplied to the petitioner in there, my lord, petition, in that petition date is there, my lord. Regarding while after serving the notice, police has again, my lord, returned that, my lord, annexure A. In that, in there, my lord, date is not there. Probably already other, my lord, annexed document which were already served to the petitioner, my victim, my lord. There, my lord, date of the
All right, then let us append an amicus.
Yes,
If the victim comes, then an additional PP submits that
Lordship.
notice has been served upon the respondent number 2 yesterday, that is 3/2. Yesterday, that is 3/2. Don't say yesterday, notice has already been served upon the respondent number 2. None appears for the respondent number 2. English so and so is appointed as amicus. Present represent respondent number 2. Copies we served upon the amicus. List again on
well to, my lord.
seven is Saturday.
Yes, Saturday, my lord,
Saturday is a fixed matter with the consent of the council. That is what has been decided today.
then on, my lord, 9th.
They don't want to appear, then we list it on another date. 9th. Sixth. Today is fourth. Right, you can serve. Micas. Sixth.
Nice lunch.
May please, your lordship. CD is called for, my lord. Here, my lord, there are 4 petitioner, my lord, and the FIR is at page number 19, my lord. Thirteen is the from 13 it started, my lord. The type translated copy, my lord. Allegation is that, my lord, some vehicle was seized with kettles on those vehicles, and my lord, some person was arrested. Here before your lordship are the petitioner who have their kettle on the vehicle, my lord. Page number 13, my lord, is the FIR. Some vehicle was seized by the police, my lord, wherein some kettles are there, and arrested some person, my lord. Here before your lordship are the petitioner who have kettles, who purchase kettles, and those kettles are loaded on those vehicles, my lord. Here before your lordship is 4 petitioner, my lord. Petitioner number 1 have 15 kettles, the petitioner number 2 have 5 kettles, the petitioner number 3 have 6, and 4 have 8 kettles, my lord, among the kettles which are seized, my lord. May I read, my lord? FIR.
Yes, what is there in the CD?
My lord, here CD received, my lord. Here, my lord, total 98 numbers of cows, kettles are recovered from 3 vehicles, my lord. They have claimed that, my lord, they are the owner of the kettle, my lord. At that time, when the vehicle are seized, my lord, by the police, they have failed to produce any, the driver and handyman failed to produce any documents regarding the, my lord, whether it is purchased or from where it was taken. On that basis, it was suspected that it was stolen, my lord. Thereafter, my lord, some of the, my lord, when it was in the media, my lord, portal, my lord, some of the, my lord, owner of the, my lord, kettle, they have identified. Their tag is there, my lord. In the cow is at present there some tag mark is there, my lord, in the kettle, my lord. They were identified, 7 identified kettle, my lord, as they have claimed that it was stolen from their home, my lord. That allegation is also there, my lord.
In this regard, my lord, my submission is that, my lord, the kettles which we have purchased, my lord, receipts are there in the vehicles, but we have collected the copy of carbon copy of the receipt, my lord, from the market from where we purchased. But as we are not in interim, therefore we could not produce those receipt before the IO to verify it, my lord. Verification of our receipt can be, my lord, proved whether the kettles we are claiming.
Verification is to be done by the IO at the original source.
Yes, ma'am. But yes, my lord. We have the carbon copy of the receipt, my lord. That can be verified, my lord.
Produce any documents, my lord.
Because we are not in the vehicle, my lord. We are the owner. The drivers were arrested, my lord.
Drivers, handymen were arrested.
Yes, my lord. They are arrested. So if we are given a chance, my lord, we will produce the receipt, carbon copy of the receipt. They can verify it from the market, my lord.
But there is some stolen kettles are also there, including
Whether
the
those,
90, my lord.
yes, my lord, whether those kettle are those kettle are belongs to us or not, whether the documents we will produce, my lord. After verifying that, it will be coming to light whether the kettles which we are claiming are stolen or not. Because we are not claiming all the kettles, my lord. 98 kettles are not claiming by us, my lord. And my learned senior colleague has said that seven kettles were identified as stolen, my lord. But we are not claiming 98, my lord. We have limited kettle, my lord.
But in the vehicle, all of them, my lord, whether it was stolen or purchasing all the, my lord, 98, my lord.
That is a
Although they
different
have
thing
claimed,
because
my lord.
many kettles were loaded in the vehicles, my lord. and some kettles are ours. After verifying that, the IO can come to an conclusions whether the kettles which we are claiming, my lord, are stolen or not. Without verifying our documents, it cannot be said, because from the 90th, only 7 kettles are identified as a.
They've sent somebody with the documents to the IO. You need not have personally gone.
What happened, my lord? One person went, but he was arrested before I could file this anticipatory bail petition, my lord. My lord,
And none of the, my lord, owners of the, my lord, as per IO, my lord, none of the owner of the cattle has appeared before the IO for verification or any produce any documents, my lord, regarding their claim, my lord.
Initially, 5 owners has come to me for filing anticipatory bail petition, and one went to the other place, but he was arrested. Therefore, they filed this anticipatory bail petition, because one was arrested.
All right, I heard learned counsel for the petitioner and an additional PP. The present case relates to illegal transportation of cattle. The present petitioners claim to be the owners of the cattle and submitted by learned PP that the owners have not appeared before the IO to submit the necessary documents which would establish that they are the legal purchasers of the cattle. On the other hand, learned counsel for the petitioner submits that in the absence of interim protection, the owners present petitioners apprehend that upon their appearance before the IO, they may be arrested. Keeping in view the above, provided that the petitioner shall appear before the IO along with the necessary documents within a period of 7 days from today. Such appearance. In the event of their arrest, they shall be released on interim bail of ₹1,000 each with security of like amount each to the satisfaction of the arresting authority. The CD be sent back for resubmission. The next date fixed after recording of the statements of the present petitioners. Report
27.
and also with report verification of the documents that may be submitted by the petitioners. The matter again on.
Please, Your Lord. Lordship, anticipated bail application, Lordships, FIR and the page number 13, my Lordship.
My lord, here we have received the case diary, my lord. From the case diary, my lord, it reveals that, my lord, it is not a fit case to grant interim protection, my lord. Here gang rape is there, my lord, and video, it was viral in the, my lord, media, my lord, social media, and some photographs are also here, my lord, regarding the viral of the video, my lord. And the present petitioner is the, my lord, main person, my lord, who has initially committed the offense. Thereafter, by treating the viral of the video, my lord, several persons committed the offense again, my lord. The allegation, my lord, my submission is that, my lord, may kindly increase some of the statement, my lord, and not a fit case to grant, my lord, interim protection, my lord. It is the gang rape, my lord.
Lordships,
If you have received the CD, what is the question of interim now?
My lord?
You have received the CD,
CD
isn't
received,
it?
my lord. CD received.
So we are not considering interim now.
My lord.
is it?
Lordships,
My submission is that it is not the case of, my lord, granting bail, my lord, not even interim, my lord.
Lordship, the petitioner totally not involved in this case, my Lordships. He is a businessman, my Lordships. He has a fair price shop, my Lordships. And the informant went to the house of the petitioners and approached some unknown person name has been inserted in the ration card. When he declined, that he negotiated and started to harass the petitioner, my lordships. My lordship, page number 5, my lordship, I have stated clearly, para number 4 and 5.
Lordship, kindly page 183 statement of the statement of co-accused, some photographs which were viral, my lord.
In connection with this case, my lordships, one accused person was enlarged on bail by the subordinate court, my lordships. I will face the trial.
Not at this stage, my
My
lord.
humble prayer,
I
lordship, by
strong
imposing
objection,
any
my
condition, I will be allowed to go on bail.
It will
I
examine
will
the
face the
CD.
trial, my lordships.
My submission is that it is not a fit case to grant bail, my lord.
I'm appealing for the that the age also has to be class 6 student, my lord. That also should be taken into consideration.
My lordships, she is major one, my lordships. She is a divorcee, my lordship.
Class
No,
6
no,
divorcee.
no, class, living sir, school certificate.
My lordship, 15 years old, voice is mentioned in the FIR, 15 years. But actually, my lordship, is a divorcee.
Any certificate is there.
Before reading the impugn order, my lord, may I draw your lordship attention. In this case, the land grabbing court called for the report from the circle officer. And your lordship kindly see page 76 of the report, my lord. Page 76, my lord.
Just a moment.
Your lordship might have got it. With reference to the subject cited above, I have the honor to submit below the reports to the direction made in the notice of the Honorable Court in the special land grabbing case number so-and-so, Habibur Rahman versus Asif Ali and others. That as per the records available after resettlement operations in Greater Guwahati, the land measuring about 5 acres 2 quarters 5.83 lachas covered by dag number so-and-so, patta number so-and-so village, Borgvari under Beltala Moja in Esbani land, wherein 74 numbers of recorded pattadars are there. That as per the Honorable Court order, undersigned has directed the LR staff to visit and inquiry the land covered by dag number so-and-so, patta number so-and-so of village Borgvari under Beltola Moja. That it is also seen that the informant has submitted photocopy of the sale deed for the land measuring about 3 acres covered by dag number so-and-so KP patta number so-and-so village Borgvari under Beltola Moja.
We will have to hear the matter fully. Let's fix it for hearing.
My lord?
Have to hear the matter fully. And just dispose it of in the admission stage. Learned counsel for the petitioner, appearing for the respondent number.
Respondent number 227, my lord.
7.
On humble prayer, my lord, that was also made in the earlier occasion. I may be allowed in between to file my affidavit.
Yes, yes.
It is always open to anyone. Whenever matter comes, he is making the same prayer, but
Admitted
he
for
does not file.
hearing. List the matter for hearing on so and so. In the meantime, respondents may file their affidavit.
Date. 10th part.
Okay. Right, hold on.
None appears for the petitioners. This was last listed the year 2016. Trial court record is here, is it? Fine. It appears that the respondent number 2 not been served. Hence, issue court notice to the petitioner. Is the matter again on officer data duty.
May I please tell Lordship, this matter has been already settled in Lok Adalat. Came from an Act appeal. We have filed an affidavit on 15/2/2023.
Affidavit on
15/2/2023.
Heard learned counsel for the petitioner. Submitted that the matter has already been settled. The Lok Adalat. Then affidavit annexing the agreement dated 28/08/2020. The petitioner.
And an order of Lok Adalat 12/3/22.
Agreement is between petitioner and whom? Respondent number 2.
Yes, respondent number.
And number 2. Containing the terms of such settlement. Here is the order dated 12/3/22 passed by the learned National Lok Adalat. What is required to be done now? The order.
Dispose order may be passed by this honorable. We have to submit before the trial court.
The present petition is disposed of. The petitioners may approach the learned trial court with the order passed by the learned Lok Adalat.
Highly honored.
Item 43, this appeal against equitable estate has filed this, 2 weeks time may be allowed to take fresh steps. 2 weeks time may be allowed to take fresh step. Earlier a direction is there to take fresh steps.
It for by learned additional PP further 2 weeks time is granted to take steps. Please again on.
9th of March.
May I please refer to Lordship? Lordship, in this case, LCR has already been received. Lordship, kindly fix a short date for hearing, Lordship.
CD has been received. Please the matter for what hearing?
Yes, Lordship, for hearing.
Grateful Lordship.
Is the TCR?
My lord, I'm seeking two time, my lord, to file the affidavit. My lord, in this matter, I recently gathered that proclamation has been issued against the accused, my lord. Online copy of the order. I'll file an affidavit annexing the certified copy of the order, my lord.
Representing whom?
Kalra, my lord, the respondent. The complainant, my lord.
Wait. Wait for by learned counsel for. Then number two,
Sole respondent.
sole respondent. 2 weeks further time is granted to file counter. Release the matter again on.
Grateful, madam.
As per the office note dated 2/2/26, Lordship. The respondent number 2 has appeared, Lordship.
Learned counsel for the petitioner. Counsel has entered appearance for number 2. Hence, release the matter for admission hearing on.
Obliged to your Lordship.
May I please, Your Lordship? Your Lordship may kindly fix this matter on 6, Your Lordship, because there needs to be an urgent hearing in this matter, Your Lordship.
Insufficient address on respondent number 2.
But Your Lordship, the steps were taken in the right address according to the FI format. There are 2 addresses, Your Lordship.
What is the urgency?
Lordship, the matter is fixed before the trial court on 7th. Your Lordship, if I recall on 21st January, it was listed in the orders column only. Today also, Your Lordship, there is an urgent need of hearing because there has been no interim stay or order, Your Lordship.
This is the victim, Hazarika.
Yes, Anindita Hazarika.
House number is given, Konoklota Port, Bhangagor. What
House
more
number
address
12.
is required? Put on the prayer of learned counsel for the petitioner list the matter on 6th.
6th of Feb, Your Honor.
PCR has been received.
Yes, Your Honor. This year. Obliged, Your Lordship.
Revision petition has been filed by the state. Today, matter is the one delay condition petition is also there. I have taken steps. Publish report.
But service not complete. It is submitted by learned additional PP that steps have been taken. Service is not complete. Which service? List again on.
Into.
Lordship, as of now, no intimation whether they would be able to conduct a matter or not. Just that they have taken a time being.
So what's the matter?
This is regarding a bail application matter. 23. And we are not into the merits of the case. Basically, we have filed this application on the ground of non-compliance of the statutory provision as mandated under Article 22(1) in respect of the notice which needs to be served under Section 48 of the BNSS. That is number one whole ground. Then the second ground comes the prolonged incarceration, followed by the fact that already charge sheet have been submitted on way back on 1/2/2025 in this matter. Additional charge sheet as well as supplementary charge sheet has not yet been submitted. Neither prosecution sanction has been accorded, and as such, the petitioner has been languishing behind bar since 455 days. Now, the fact remains is that on the earlier occasion in the lower court below, this particular plea was not taken regarding the non-compliance of the mandatory provision, and as such, the bail got rejected during the fact that the merit of the case was before the honorable court. But now here we are taking that plea because we have gone through the records and it has come to the knowledge of the petitioner, including from the objection which has been filed by the CBI. There itself they have admitted that maybe they do not have any knowledge about the notice that has to be served under 48 in this particular case because the petitioner was soon arrested from jail. The petitioner got arrested in one of the case and later on he was soon arrested in the CBI case. But our main moot question is that whether in a soon arrested case also they should be served with a proper 48 notice or not. They have stated that they have served somebody employable to the petitioner, but the petitioner has denied he has not nominated any person, neither any relative or his friend has been informed. Though in that particular phase of the case, the petitioner's fiance along with the mother and father were also inside the jail in this particular case. Later on, they got bail, and they are now already enlarged on bail. Now, so we are more into the context.
Right, since CBI counsel doesn't appear to be here.
Yes, that is she has to be here, and also the court has to go through the record. And if it has been served in this case, because in the objection they have stated that this notice has not been has been served to somebody, whether it has been
Heard Mr. Learned counsel for the petitioner. CBI counsel, learned counsel for CBI is not present. As per last order, CBI was required to file the objection. But it appears that the same has not been submitted as yet.
We received
Oh,
the
I
copy on
think
29.
I think something has been submitted.
On 29 itself, they have filed it.
Is objection, you cut that line required to file. CBI has already filed objection. Hence, list the matter again on
6th, my lord.
fixed. Too many cases on 6th. See. Arena 6th. 7. All right, on 7. It's that the Learned Counsel for CBI will also produce the records.
Obliged.